Thank you. I hope I live up to this, to the high expectations you just raised. I want to begin by expressing my gratitude for the invitation. I'm really honored to be here. I'm learning a lot. I learned a lot in preparing for this event, and I learned a lot yesterday and today. So it's very inspiring for me to be here. I will speak with you about one judgment of the European Court of Human Rights about urban policies in Rotterdam. But I will do so assuming that you are neither particularly interested in urban policies in Rotterdam, nor particularly interested in the European Court of Human Rights, and therefore I will take a methodological perspective. First, I will tell you about the case. The case is, the applicant, in this case before the European Court of Human Rights, is called Rohini Devi Garib. She is a Dutch national of, I think, Surinamese origin, and I think she is a Hindustani Surinamese person, so she's probably a descendant of contract laborers who originated from, at least from my perspective, from this part of India. But she's a Dutch national, and for me as a lawyer, that is the relevant part. She has two young children, she's a single mother, and she lives in a one-room apartment in Rotterdam. And her landlord offers her a 3-room apartment at 50 meters distance with a garden. And by Dutch standards, a woman with 2 children living in 1 room is unacceptable, and 3 rooms is what she needs, a living room and 2 bedrooms. However, she needs a housing permit, and that is refused. And that case reaches the European Court of Human Rights, and she loses the case. Why is the housing permit refused? Because she lives in what is informally called a hotspot, a bad neighborhood. I will say more about that. And in this bad neighborhood, you cannot get a residence permit if you are. So there's 2 conditions. You should be living in the region of Rotterdam for more than 6 years. No, I should say it differently. If you both don't live in the region of Rotterdam for more than 6 years, and if you're on welfare, then you cannot get a housing permit there. So it's people on welfare who haven't lived in the region of Rotterdam for more than 6 years. They are denied a residence permit, a housing permit, and that's why she doesn't get a housing permit. This is based on the Act on Metropolitan Problematic, the Wet Grootstedelijke Problematiek, which seeks to intervene in the demographic composition of what are called hotspots. Hotspots are these bad neighborhoods that need improvement, and improvement means that people like Ms. Garib have to leave. Predictably, this disproportionately affects migrants because of the residency requirement and the income requirement, and it disproportionately affects women because of the income requirement. I will say a bit more about the legal reasoning of the court in a minute, but first I want to say how I want to approach this case. I will first do the thing I usually do. I'm very much a discourse-oriented person, and I look at, I take a hermeneutical approach. I look at language. So I ask the question, I will start with that. I will begin by asking the question, how does the legal reasoning of the court succeed in making it look logical and even necessary that Ms. Garib and her 2 children are not permitted to move 50 meters from a clearly unsuitable home to a clearly suitable home? How does the court succeed in making that look logical? The court does that essentially by linking poverty to crime, because it's a poor neighborhood, and poor neighborhoods are characterized by criminality, and very explicitly to class. It's poor people, and implicitly race and gender are involved. So these 3 elements, class, race, and gender, are intermingled to reach this effect of naturalness. However, in addition to my normal analysis, and in great part inspired by what I expected to find here, I thought maybe I should do two more things. Maybe I should add a distributive analysis that asks the question, how does this judgment impact the power relations between individuals and landlords? Because this is an intervention in an economic relation. What does it do there? Now, that will be the second thing, the distributive analysis. And thirdly, I will try to develop my version of an ideology critique. How does this judgment affect the general socio-economic and political position of the excluded group, of the underclass, people living in hotspots? And how does it impact their capacity to resist? And then, by way of conclusion, I will try to ask the question of what social actors, political subjects, including academics and legal practitioners, can do to contribute to changing not only the legal outcome of cases like this, but also the reality behind the legal outcome. Okay. 3 parts: discourse analysis, distributive analysis, and ideology critique. I begin with the discourse analysis. So this is what I feel very at home doing. If you look at the history of the law that is at stake in this case, it starts in 1972 with anti-immigrant riots in Rotterdam. You see that the 2 criteria, the source of income, so being on welfare, and the 6 years of residence, have been developed so as to target migrants, and in particular non-Western migrants. The earliest version of this legislation said so explicitly. So they excluded migrants, and that was struck down, but it was annulled by the central government because of a violation of the Convention on the Elimination of All Forms of Racial Discrimination. So they learned that you couldn't do that. You couldn't mention that you wanted to get rid of migrants. So you have to do that without saying those words. In the judgment, you very clearly see that, because the court uses 4 groups of interrelated code words, and these code words taken together signal migrants. First of all, they all the time use the word socio-economically underprivileged. That doesn't necessarily mean brown people, but it's the first group you think of. Secondly, they link inappropriate behavior, nuisance, crime, and migrants and illegal migrants. That is clearly a racial category. Third, they use spatial terms. They use terms like concentration, segregation, and, remarkably, the isolation of the native born. So apparently, white natives feel isolated by all these brown people in their neighborhood, feel crowded out. And fourthly, they use emotional terms. There's dissatisfaction among the population, presumably among the native-born population, but that doesn't say, they don't say so explicitly. And they speak of the quality of life and of distress areas. So that's emotional language. In doing so, they use the language of socioeconomic position, criminal behavior, concentration, segregation, and quality of life, distress. That together essentially means that the dangerous class, and it's a very classical move dating back to the 19th century, the dangerous class is considered as a race, and it's characterized by material and spiritual poverty, by criminality, by physical and moral defects, by dirtiness, and by sexual promiscuity. How else could you become a single mother? Now, the surprising thing is that the European Convention of Human Rights gives individuals, everyone with legal residence in a country, and Garib is a Dutch national, so by definition she has legal residence. It gives everyone the right, the freedom to choose their residence. And this is clearly an interference with that. Now, Because there's few lawyers in the room, I will try to keep the legal part short, but it's an important element of my analysis. You would expect the European Court of Human Rights to put the burden of justification on the state and to say, dear state authorities, this woman has a freedom to choose her residence. She is allowed, the proprietor, the landlord allows her to rent an apartment, and you say that she cannot realize that right. She cannot enter into a private law contract. You have to justify that. However, the court does something else, and it does something that it only does in migration law. In migration law, the European Court of Human Rights, like other courts in the global north, doesn't begin with individual rights, but it begins with the right of the state. Every state has the right to control migration, and the right of individuals functions as an exception to the right of the state. That is, human rights turned upside down. Because normally an individual has a right, the individual does not have to, I don't have to justify towards the Indian state why I'm saying what I'm saying now. It's up to the Indian state to justify why they want to stop me from speaking. Yeah, so that's the normal, a completely unspectacular way of applying human rights, except in migration. And what is striking is that the court here succeeds through all kinds of technicalities that I will spare you, to do exactly the same. So they say the state has the right to engage in socio-economic policies, including urban policies. And if they do that, they should have a wide margin of appreciation, because it's very political. Socio-economic policy is very political. There's many different options. And in such a case, it's not up to a court to replace the government's socio-economic policies by its own. So it should keep distance. It should give the government a lot of discretion. And so we will do a very distant tests. Only when it's completely irrational, socio-economic policies can be annulled by courts. Yeah? And so they say, well, this is a very legitimate policy. And therefore, Ms. Garib has to justify what is her problem. And then the court says, and they say this several times, and apparently they don't see how funny it is. They say, Ms. Garib has not justified why it's so important that she moves to the other apartment. So she has to justify why she wants to use her right. And in addition to that, in a Western European context, a mother with 2 children wanting to move from a 1-room apartment to a 3-part, it's a no-brainer. We all understand why she wants to do that. Every responsible parent would want to do that. But the court says she hasn't shown a force majeure or something, and therefore she can be denied that right. And that is something you would expect in a migration case, but not in a case about the right to choose your residence. So, I will formulate a hypothesis, and normally my analysis would end there. My hypothesis is that European human rights law, at face value, is based on territoriality. You can exercise a human right if you're on the territory of the country, of the number of countries that are bound by the European Convention of Human Rights. However, I begin to suspect, and I formulated this first as a hypothesis in the context of migration, but I now also see it in this housing case. I begin to suspect that the court, in addition to that, succeeds in recreating a system of personal jurisdiction that was characteristic of colonial rule. I know this best from the Dutch East Indies. There you had the law for Europeans, the law for the natives, because of course it would be inappropriate for people as enlightened as the Dutch to subject natives to European law, for example, to European family law. We were so broad-minded they could have their own family law. And we also had a few extra criminal provisions that didn't apply to Europeans. And then you had for the foreign Orientals, for Chinese and Japanese, you had a third system of law. That is a personal system of law, not a territorial system of law. And what I think the European Court is developing here is a similar personal system, a personal jurisdiction that succeeds in applying different laws to different groups of people. I think it's also at work in criminal law, but that's just, I say that as a newspaper reader and not as an academic researcher. If we simply look at the people who are in our prisons, we also see that they're all brown. Must be something. I guess criminal law is something similar, but no doubt it uses a completely different technique than the one I outline here. Okay. That's the discursive analysis. And normally I would say, well, I did a nice job. I showed that all this is colonial, terrible, wrong, wrong, wrong. However, I think we can say more. This policy of dispersal, which, by the way, is only applied in Rotterdam. The informal name is the Rotterdam Act. It's a national act to give in to pressure of the Rotterdam government, which has been busy implementing this kind of legislation since 1972. No other municipal government thinks this is a good idea. But in order to please the people in Rotterdam, there's this national legislation. Now, what these dispersal policies do is to affect the public segment of the housing sector. And by that, I mean the sector of which the rent is controlled. The rents are controlled up to a certain level, a certain amount of money, and that is the sector of housing that is available for poor people. This rent-controlled part of the housing market is both publicly owned by housing corporations and partly it's privately owned by landlords who are trying to make profit. And Ms. Garib was renting from a private landlord. Now, the dispersal policies, of which Ms. Garib was the object, make it impossible for the targeted group to rent apartments in a part of the city of Rotterdam. Yeah, the targeted group, in fact, if you look at social science research about who is affected by these policies, it is non-European migrants, it's Eastern European migrants, so people from Poland, Romania, Bulgaria, who have a fantastic legal status, but very poor labor conditions, because European law is not only used to give them a residence right, but also to import, let's say, Romanian labor standards in Rotterdam through all kinds of legal constructions. And single mothers are an important part of this group as well. So it affects very identifiable categories of people. And for these people, it becomes harder to rent an apartment because the number of houses that they can potentially get is smaller because they are banned from renting in part of the city. So the number of available apartments is smaller than for the rest of the population. And as a consequence, the position of the excluded group vis-à-vis landlords becomes weaker if you apply very basic third-grade microeconomic analysis. You have less to choose, so you have less power, in particular in a market that is dominated by landlords like the housing market. So these people, these migrants and single women, become more dependent on landlords than the other group. In particular, vis-à-vis the private landlords, because the public, the housing corporations, they function in a very bureaucratic manner, and I don't think they will make a difference between different groups of people. At least I hope so. I'm not entirely sure, but let's say they don't. It does impact, in particular, the relation of these group of migrants and single women vis-à-vis private landlords, and that is precisely the group of landlords that is bound to take advantage of power differences. These people become, as a consequence, more dependent on slum landlords and are more likely to have to rent a room instead of an apartment, or even a bed in a room. And that is exactly what we see in particular among Eastern European labor migrants in my part of Europe. So under the guise of this very abstract margin of appreciation that I mentioned, that in socio-economic policies, courts have to, shouldn't better guess the government, the court in fact does something else. It participates in actively deteriorating the position of a group that is already pretty vulnerable. These are migrants and single women are very vulnerable groups on the housing market, and they get an extra push in the wrong direction from the court. That is my distributive analysis. So I think we should add that. And this is, it's not for a lawyer, it's a bit unusual to do this, but I think, yeah, it's what the law does, and it doesn't take a rocket science form of economics, so we lawyers can do that. Then I want to address the ideological effect of the judgment. And I think that the main so the elevator pitch for that would be that the court treats inequality not as injustice, but as an identity matter. And we will see that the dissenting opinions, which seem off the wall, radical to a European audience, they do exactly the same. Both the domestic law and policy and the court's reasoning acknowledge that the inhabitants of the hotspots, of these bad neighborhoods, and in particular the excluded group, that these people are socioeconomically disadvantaged. That's the term that's used time and again in the judgment and also in the legislation, in the Dutch case law about this law. Socioeconomic disadvantage. So you would expect that that comes with a socioeconomic analysis, but that's not the case. So as I said, it's treated as an identity issue. It's not about oppression, it's not about appropriation and inequality, but it's about bad behavior combined with space. And that's a surprising thing. Socioeconomic disadvantage is related to bad behavior and space. So what the court identifies is the problem that in a single space, too many badly behaving young men, because things like inappropriate behavior, nuisance and crime have a gender, and too many badly behaving young women, because they're single mothers, then you must be badly behaved, are concentrated and segregated. And this is seen as a spatial issue and not as an issue of class justice. Because you could also say, and it would be more rational to say, I think, well, if people are poor, what they need is not to be dispersed over the city, they need more money. So, in very basic terms, you would say the lower class gets too little of the surplus value generated by capital, and indeed, in my part of Europe, you've seen the part of the production, of the financial production that goes to labor becoming smaller and smaller and smaller since over the past 35 years. And the solution for people is not to disperse them, but to give them a bigger part of the profit, to raise their salaries and keep rents under control at the same time. So the court takes part in representing socioeconomic inequality as an identity problem to be managed through urban management and upward mobility. People should go up through upward mobility, or out, they should be dispersed. So the court participates in replicating and reproducing the underclass. Now, the funny thing is that the problem which the court identifies and puts very central in a very convincing way is that the problem is recognizable. There is an urban underclass which, in addition to class, is related to race and to gender. In European statistics, both income and wealth, so class, is closely related to class and gender. You see that time and again. And that's not becoming any less over the past decades. Now, what I think you see here is a consequence of the following. After 1990, in particular, it began a bit earlier, but after 1990, European states, Northwest European states, have inserted into their very social, democratic, and highly regulated labor markets, they have inserted a low-wage economy into that. And that low-wage economy is very much raced and gendered. This low-wage economy is in domestic work, in construction, in agriculture, in food processing, in distribution, and in retail. And with the exception of distribution and retail, these are completely gendered. They're either male or female. These sectors are heavily gendered. And the low-wage economy depends precisely on the excluded groups, on immigrants from outside the EU and Eastern Europe. And people in the Netherlands are called immigrants even when they are Dutch nationals, because then you're second generation or even third generation. We have ways we have a kind of Freudian denial of the Dutchness of people when they're not white. The dispersal policy, so the material part of the policy, makes it harder for this underclass to stay together and join forces and resist. And it may sound a bit idealistic and over-politicized, but of course there are riots in this kind of neighborhoods, and that was what started it in 1972. And it hasn't been as big and as mediatized as the riots in the French banlieues, but there is a constant public order problem of youngsters rioting and fighting with the police in these neighborhoods. And I think it's artificial not to relate that to their in the terms of the court, their socio-economic position. What dispersal does is to make it harder to get together and hang out and have fun by throwing stones at the police. And this is becoming, I think, politically relevant now. People, I always have a problem in how to indicate this, because I resist the notion people with a migrant background, because after 50 years, I think these people are simply Dutch and don't have a migrant background. So Dutch people of color, I think, as they are going through the universities and becoming professors, journalists, politicians, filmmakers, I think these people become more articulate, and the interest in dispersing them becomes bigger, because they might do more than just have fun on Friday nights by throwing stones at the police, and they might become more political. And the dispersal policies make this harder. There's a second way, a related way. It's a bit a different way of saying the same thing, but I think it needs to be said nonetheless. The representation of socioeconomic inequality as an identity issue makes it harder to articulate social justice-based opposition to the low-wage economy, because it's a personal defect. If you're on welfare, you simply should move up or out. You should do something instead of try to change the system. So by pointing to urban renewal and upward mobility as the way out, the representation that the court participates in links to neoliberalism, because that assumes that the rising tide will raise all boats. A structural analysis to the contrary would argue that a higher minimum wage would help. A prohibition of structural temping, which is the problem of Eastern European workers in the Netherlands, because they work under Romanian or Bulgarian contracts with scandalously low wages, through which they cannot afford proper housing, because that's way above their pay grade. So that would help. So a prohibition of a higher minimum wage, a prohibition of structural temping and secondment, recognizing domestic work as work. People cannot get a residence permit for domestic work because under Dutch law, it's not, under Dutch labor law even, it's not considered actual work. This would offer a way to limit, to combat, to do something about the low wage economy that has been inserted into the high wage economy the compromise, the social compromise between 45 and 1990 put in place. And it would open a non-revolutionary reformist path to social justice that does not rock the boat, that leaves capitalism in place, no harm done, so to speak, but which does not play off against each other different segments of the underclass along lines of class, race, and gender. In the field of housing, you could imagine similar redistributive policies that would follow a structural and not an individual analysis. You would say, well, we need a larger housing, a larger part of the public sector should be owned by housing corporations because they're more reliable, they're less likely to exploit people. We should redistribute larger apartments. Elderly couples now often live in very big apartments because their children left home. They're in principle willing to move, but as soon as they do that, the rent will go up because of how the public sector pricing is structured. So, and you should end privileges for house owners and investors. There's an enormous tax advantage for both private house owners and investors. Okay, so that ends my ideology critique. The court makes it harder for the let's say the underclass to join forces and resist, and it makes it harder to even formulate a structural, a justice-based opposition to the policy at stake. Now, what does this mean for human rights? Because something in me is extremely skeptical and pessimistic about the promise of human rights. So let me look at the strongest dissenting opinion in the Garib judgment. There's one dissenting opinion that goes very far because it says that the aim, one of the things you need in human rights law if the state wants to interfere with a basic right, one of the many requirements, one of the 5 requirements, is a legitimate aim. And this judge does the spectacular thing of saying the aim is illegitimate. And that's pretty woo. And he says, at first sight, and that's important for what I will say later, at first sight the aim of the dispersal policy at surface, it's legitimate because de-ghettoization and urban regeneration, that is the terms the dissenting judge uses, de-ghettoization and regeneration are legitimate aims. But the underlying real aim, and by that he means the means through which these legitimate aims can be achieved, that is illegitimate because the policy aims to remove the underprivileged. And so this judge says the actual aim of the policy is illegitimate. And that's the same judge says that linking poverty and public order problems is stereotypical and therefore not acceptable. And even if the aim is accepted, you should apply a strict scrutiny. So there should be very intense judicial control instead of this wide margin of appreciation. Because it concerns a core right. The right to choose your domicile is a core right, and it concerns a vulnerable group. In this case, a single woman, a single mother. However, the dissenting opinion remains strictly within the hermeneutical approach. If the dissenting opinion would have been accepted by the majority, That would change this distributive outcome because it would ban this kind of policies, but it would not change the ideological effect fundamentally. The dissenting opinion accepts the existence of the underclass as a given. It doesn't question that. But it insists that the underclass should be treated as fellow human beings. We should be kind. We, middle and upper class people, should be kind to the underclass. The double spatial move up or out of neoliberalism is not noticed by the dissenting judge or contested. And in that sense, the dissent reproduces the ideological motives of the majority. It proposes a humanized version of neoliberalism. I think an ideology critique, as I try to develop here, can try to counter that ideological impact. Poverty can be seen as an issue of distribution, not as an identity issue or a personal shortcoming. And the aim of dispersing or diluting the underclass and preventing unrest, so preventing forms of resistance, and if it's just rioting, then it's unarticulated resistance, but still resistance. That aim is illegitimate. And the solution for this is not humanizing neoliberalism, but is social justice, fundamental redistribution, and not social engineering. So by way of conclusion, I think that human rights by itself has very limited transformative potential. Because in isolation of social movements, it remains caught in the cage of liberal discourse. And there I think discourse analysis is really valuable, because it shows how discourse has no outside. And there is some space for maneuver, as the dissenting opinion shows. So the legal outcome is not given, but the political space remains very limited. However, in combination with social mobilization, human rights law may be more productive. And I want to give one example. This judgment is from 2017, so it's quite old. In 2020, I don't know about here, but in my part of Europe, there was a very vocal Black Lives Matter movement. And two years later, a number of NGOs, together with a number of individuals, began litigating against racial profiling in border control. And to my total surprise, they won the case. So the use of any racial characteristic is banned in border control. Of course, it's not banned in actual border control, but it's forbidden to use it in the written instructions, and it used to be a factor in the written instructions. And I think that is inconceivable without Black Lives Matter. Similarly, there is a question before the EU Court of Justice, so the other European court, the EU court, about visa policies, which the Council of State has asked. The Council of State thinks this is okay, but just to be sure, it has asked the Court of Justice whether that is a discrimination on the basis of nationality, because if you look at the visa, the nationalities that require visa, they're all brown, so to speak. So if you look at the world map and the Schengen visa map, it's completely obvious what this is about. And this is, again, it's inconceivable before Black Lives Matter that the Council of State would ask the question to the Luxembourg court about this, because they would say, no, it's nonsensical. Of course, this is not discrimination. So, in combination with social mobilization, this may be powerful. And I think that combination of a hermeneutic and political economy analysis of law that such as I've tried to develop may help in doing two things. First of all, creating or imagining space for contestation, take part in articulating social justice critique, even when you lose the court case, because the case may be a focal point for mobilization. A second thing it may help doing is that if a social movement has politically achieved something, it may help in writing that a bit in stone. Because, of course, case law, jurisprudence is not really written in stone, but at least if you have a decision of the Supreme Court, you have quite something. I think we see something like that in the prohibition of arms export to Israel. As I said, the prohibition of racial profiling and border control, and in climate litigation, where I think the successful litigation essentially solidified achievements of social movements. That's where I want to leave it. Thank you.
Thank you so much, Thomas. This sort of feeds into, I haven't said a lot about him when I was introducing him. One of his first probably pro bono job was in housing. You were a volunteer for the housing movement, yes. And he's always interested in questions of race, coloniality, justice. This has been quite a food for all of us, food for thought for all of us. So I'm opening this up for your discussion, questions. My question is, I will begin with my question. My question is, it's something that always intrigues me, because space and criminality has been wonderfully used in the context of India or Ireland by the British. You know, the criminal laws or laws against, not even criminal laws, laws against gathering. For example, we had this famous Jallianwala Bagh case where people gathered peacefully, women and children were shot at and killed. Hundreds of them were killed. And General O'Dwyer, who was an Irish, who said that had I more ammunition and if I could bring the tanks, I would have done that. So, you know, this relationship with space and criminality is something very obvious in our context. What is interesting for me is this conflation that you're making with Black Lives Matter and the legitimacy of certain kinds of demands for justice. But I look at it from a different perspective. I think this whole movement for Black Lives Matter is not so much vis-a-vis whites and blacks, but more vis-a-vis browns and blacks. The polarization is now against, let's say, in certain ways, Africans and Asians. And somewhere in the cracks, the West Asians or the Palestinians, they fall through that. So this has been used for a further polarization of races, according to me, and I would like to ask you your opinion on that, for the purposes of retaining the hegemony of the whites, retaining their rights to discard and disperse people, notwithstanding what the European law offer, because this whole question of, the rule of law that Europe is so proud about, just doesn't, you're so right that it just doesn't disperse to other races. It's for the whites only. So I think it was a fantastic lecture, and I'm very glad. You have my questions. I have other questions, but I'll restrict myself and I'll open it for, maybe you can take a few questions and then make your response. So questions, anybody, comments, discussions? Yes, Shamota.
Thank you. I have a comment and followed by a question. The comment is about your observation that at times social movements end up bringing about legislative change, and I just wanted to connect it to Shamim's presentation earlier in the day when he was talking about he's registering a shift in the way he notices queer self-expression in the two journals that he talked about before decriminalization. So the moment of movement building for queer individuals, then the point of decriminalization with the intervention of the court, and then he shows us another way in which self-expression is now congealed. So I just wanted to say that I agree with this, and today already we've had a similar example. But my question also ties in very slightly, but with Paula with the idea of colonialism. So, and you talked about how domestic work is not recognized as work, and therefore it's very difficult to get residential permits if you are applying for it as a domestic worker. And we know that in the history of Dutch colonialism, Indonesian domestic workers have had a big part to play, and I think they continue to do so. So, taking a cue from Pallavi, my question is also, so this racialization of certain kinds of work and refusing to accommodate such people or to keep them confined in certain areas is also colonial in nature. It's not merely then this neoliberal racism, but also older forms of racism.
Hi, I am Oishika, and I actually did my master's in Utrecht, and I also had the pleasure to learn a little bit about the Rotterdam Act that you were talking about, and I also live in Rotterdam, so I could also kind of contextualize a lot of the things that you were saying, of course not in terms of the lived experiences, but I wanted to kind of bring in my experience as an international student from the Global South living in the Netherlands. Because I have personally faced a lot of different visa barriers, particularly in terms of accessing the labor market or just in terms of mobility, going to a non-Schengen country, and also housing discrimination. So I wanted to understand, and since we were also talking about previously about this connection between social movements and bringing about, or the potential to bring about legislative change, would you, in your opinion, or do you have an opinion on if there could be some kind of social mobilization for the cause of the international students, especially considering the context that we are in the Netherlands, wherein there is a lot of pushback against international students, where universities have said that please don't come if you don't find housing. So considering this very kind of sensitive landscape, what are your thoughts on that? I'm not sure that's a question, more of like some reflections, but what are your thoughts on that? Thanks.
Thank you. I'm really enlightened by your very different kind of reading of law and how the non-legal matters affect law in very significant ways. And taking cue from Samota, I would like to ask that the race question has a colonial connection, but you talk about the low-wage economy in neoliberal times. So how do you respond to that? How this old colonial race question, do you think that it takes different meanings in neoliberal times if we connect it with the reproduction of low-wage economy, and how is there any change or some, what are the nuances of law regarding this, how do you connect this colonial and the neoliberal in legal terms?
Let me begin by your question about the student visa. You're completely, I completely recognize what you say also from my own international students. You should be aware that you are the privileged group. You do get a visa, you're middle class, you're well-funded, and you experience this. What to me is significant, so the kind of response I would have to your question, the kind of analysis I would make, is that the political debate in the Netherlands and other Northwest European countries is so riding on the waves of anti-brown populism. The government has forced universities to reduce the number of international students, while the same government policies force universities to attract as many students as they can, because they have a neoliberal funding foundation. So the universities are torn in two directions. The debate is not whether that is just, but whether we aren't, as you say in Dutch, slaughtering the chicken with the golden eggs. Isn't this economically silly? Because for the universities, they get more funding, but the country as a whole attracts these wildly smart people from all over the country whom we need because we don't reproduce sufficiently. So that is the debate. The debate is a purely neoliberal debate that has nothing to do with normativity, with any norm. And to me, that is concerning. That concerns me. I'm relatively unattached to the outcome of the. I think you have a good reason to go either way. To say we want less foreign students or we want more, but that this is the terms in which you carry out that debate. That is deeply problematic. Paula, you said that you were concerned that the Black Lives Matter movement. Do I understand correctly that you say it leads to less anti-black racism and more anti-Asian racism? Is that what you?
It has led into that polarization.
Right.
It's not, obviously, it wasn't, the Browns also joined, but ultimately, whether you look at donor politics, whether you look at aid politics, the whole movement is now to say that yes, Black Lives Matter, but Browns don't in the context of Europe. I mean, Browns are still considered as the quintessential, as you call it, the socio-economic underprivileged class and associated with criminality. And by Browns, I also mean the Afghans and the Syrians and that group, and not the Africans.
This is new to me. Thank you. So I'm thinking on my feet. Of course, we did notice the anti-Chinese sentiment during COVID, but I didn't connect that to Black Lives Matter. I know that in what I can see from the Black Lives Matter movement in the Netherlands, this is heavily contested. So in the Dutch, let's say, post Black Lives Matter, a major theme is slavery. And an important debate in that movement is, first of all, the role of Dutch slavery in the Dutch East Indies, which people don't know that much about, but which in absolute numbers seems to have been as big as the Dutch part of the transatlantic slave trade. I mean, in 1621, a big national hero, Jan Pieters Koen, after whom we call tunnels and bridges and squares, exterminated the inhabitants of one island of Banda because they traded with the Portuguese and not exclusively with us, and then they had to import people from elsewhere who were enslaved, just like on the Atlantic. So that's one important debate within that movement. And another one is whether the position of what in Dutch are called the Hindustanis, the contract laborers, should not be included because their terms of employment were. They were as brutal, and partly the same kind of legislation applied, where people could be beaten by their employer for bad behavior. But I agree that and you make me realize that, for example, highly symbolical acts such as the formal apology of the king and of the prime minister are all exclusively about African slave trade and the role of the Hindustanis and the Indonesian slave trade is unacknowledged.
Yeah,
But then,
Morocambo Bay case,
huh?
the Morocambo Bay case, the Chinese, the Asians, as we put it, they died. They die, so many of them. They are slaves.
Yeah.
But nobody acknowledges in Europe that this is another, with the same kind of repression.
Yeah. Okay. Thanks for the thought. I need more time to process it. The observation, Samata, that visibility may lead to vulnerability, I think that is part of that's part of the success of the far right in Europe is the success of resistance against colonialism. Black Lives Matter in the Netherlands also kick out Zwarte Piet, the protests against the blackface that are part of the children's feast that takes place on the 5th of December every year, led to deep resentment among conservatives who felt that both Black Lives Matters and the tendency of municipalities to ban or to not to organize processions with Sinterklaas, with the holy man who gives children presents, with black faces, so to make these many colored faces and so on, so to find other colors than black, have been deeply resented by conservatives because they feel something essential is taken from them away, and that essence is racism, that they're not free to be openly contemptive about black people. So it's related to the rise of the far right, I think. And similar processes have been going on in other parts of Europe, in France, with the acknowledgement of France's role in Algeria and of the killing of Algerian protesters in Paris, and it's similar dynamics. Domestic work as related to Indonesian domestic work, again, thank you. Silly, but I never thought of it before. And indeed, that's so it immediately calls up all kinds of cultural images for me, because the ayahs in the Dutch East Indies were not servants; they were part of the family. And that is exactly the terminology that is used for domestic work. You're not a servant, you're part of the family, therefore this is not a labor relation. And imagine the only way a domestic worker can get into the Netherlands is through an au pair contract. And an au pair is, again, Dutch law denies this is a labor relation. An au pair is someone who does light household work for not more than 28 hours a week. Now, translate that to a male gendered law definition. So you are not in a labor relation if you do light industrial work for no more than... nonsensical. It's nonsensical. We call this a part-time contract. And of course, au pairs are also part of the family. They do it for cultural orientation. One of the traditional reasons is that when, in the good old days, when white Dutch women, lower class white Dutch women, were cleaning house, if they would be employees, they would be entitled to old age pensions, sickness allowances, holiday leave. And it makes it way too expensive, because of course the fun of wealthy people hiring a domestic worker is that they exploit the wage difference between themselves and the domestic worker, and that wage difference should be big and not small by offering a decent wage. There's also, it's not exclusively racist. It's also a very gendered and very intra-native Dutch process. And then finally, how do colonial techniques, legal techniques, carry over into law? I think, and I take this from B.S. Chimney, whom I assume is famous here as well. He, in this context, he argues that capitalism is torn between a logic of territory and a logic of capital. Yeah, the logic of capital wants no borders, free market, free movement, free everything. But there's also within capitalism a counter currency that wants limitations, borders, selection, monopoly, so the Dutch colonization of the East Indies was justified by free trade, by my brilliant fellow countryman Hugo Croesus. But at the same time, he had to explain why the East Indians could only trade with the Dutch. And because there was free trade, he couldn't suddenly deny free trade. But then he said, yeah, the basis for the Dutch monopoly and therefore for the Dutch extermination of the inhabitants of Banda in 1621 was contract. Because we, friendly and benevolent Dutch traders, came to Banda and they said that they would be willing to trade with us, but there were these naughty Portuguese, and they asked us to protect them against. They asked us to protect the Banda themselves against the Portuguese, and we did that in exchange for a monopoly, because protecting them costs money, and we need to get something in return. So there you see, within one space and in one moment, a combination of the logic of capital and the logic of territory. And I think that you see that these are, let's say, two tendencies that draw in different directions, and the compromise between them is always unstable. And it makes it very natural to carry over the problem and some forms, some techniques from colonial times, but others have disappeared because they were inappropriate to the context. That's a very contextual thing. But I think if you see these two tendencies, these two logics at work at all times.
Next round of discussion points. May I begin like last time? Well, Shamota brought up a very interesting problem of domestic workers. The domestic workers, as we have seen the world over, 70 to 75% are women. So, it's not just race, but it's also a question of gender. That for the purposes of protecting Dutch homes, you have this very gendered labor, which is not considered as labor. But since these people are infiltrating the homes, so control over them was even more severe. So by not bringing them within the context of labor laws, you actually facilitated greater control over their bodies. And it was not, it later started becoming associated with migration, race, etc. And that sort of increased the vulnerability of the people concerned, because au pairs are also white women, but with, and I know that because my cousin and her husband, who were Americans, when they went to Europe, they had white au pairs all the time. So, but most of the people did not have white au pairs. Europeans got other au pairs. So they were allowed to enter the home within the guise of being a family, but actually they were there very well to serve, and the control over them was facilitated by not bringing them under labor law. So I would like your response to that, but please take a few more questions. I'm sure people would like to. Nasreen, any?
I actually don't have a question, so I am just happy to listen into what is going on. Thank you.
Nasreen, are you okay?
I'm very
This is a first.
Well, if you insist, then I'll think of a question.
I'm sure you will think of a question and then say that I insisted, if that makes you happy. But anyone else, please. Yes, Marion.
Thank you so much. It was very insightful presentation, presenters. So I think my question also relates with the kind of domestic worker, and maybe another question. It won't be that relates to the topic that you bring, but maybe you have the expertise on the displacement. So first, I would like to ask like about the domestic worker. Is like in Dutch in the Netherlands, domestic worker is recognizable as a profession, as a career. I mean, is it like under the law or something like that? Like, is there any like a different law about recognize the domestic worker from the native Netherlands, or maybe for domestic worker for the coming abroad? Like, because in Indonesia, domestic worker is not recognized as a career, as a profession. So it's still like informal sector, and like it's so weak and a lot of problems and issue happen. So I just would like to ask, because I think Indonesia have a shared history with the Dutch, and even until now we still have implement some of the Dutch law. So I hope it can maybe for further recommendation for Indonesian law. And then also the second question about the displacement. So historically, after the colonialization, in the perspective of an Indonesian history, all of the Dutch coming back to the Netherlands. And then some of them bringing also the Indonesian as their like domestic worker or something like that. So I think there is also some cities in Netherlands that have a lot of Indonesian descendants there. So is it like how are they now like are they become the like are they can them get the naturalization, or it's not possible for them, like how they survive there, like historically and then until now? I know there's a lot of the historical period, but you can like briefly explain me about it. Thank you.
Hello, thank you for the presentation. It was very interesting. Coming from Portugal, Europe overall, I think there was a few things that I could kind of, well, make parallelism with, I would say. And I lived for a while in the city of Lisbon. And when I was listening to you refer to the de-ghettoizing, I don't know if that's the word, of certain neighborhoods where there would be more migrants living and that would be associated with insecurity, for example, I was thinking of historical neighborhoods in Lisbon that were historically inhabited by the Moors a long time ago, or maybe the Jews at that point of time too, and nowadays by migrants. And the same worries surround those neighborhoods by politicians, by part of the population, and it has a lot to do with discourse, obviously. And what is happening, and what has been happening for a few decades now in those areas, is that there's these regeneration policies, but I feel like they're very targeted at a gentrification of the areas. And the difference here would be that they're not rent controlled. There's not such kind of policies there. So what we find is that there's people with higher, let's say, poder de compra. Acquisition power, let's say, that are able to rent those places, and migrants are then displaced, like maybe other people were at some point in time. Nowadays, Airbnbs are also all over those areas because they're becoming trendy and hipster, and everyone wants to be there, but migrants have no place there anymore. And I don't know, I look at Rotterdam, and I was there only once, and I saw that there was this new museum, Phoenix, about migration. It's this art contemporary museum about migrants. There's also this very known market that sells food and products from all over the world. So it feels like, again, migrants are being commodified for their culture, let's say, for what they can provide to the privileged ones that go to these places, but then they don't have a place to live, as you're explaining as well. So I kind of want to reflect on maybe what kind of realities are there in Rotterdam in terms of gentrification and touristification, if you could maybe talk a little bit about it. Thank you.
Thank you so much. Any last question? Because this will be actually the last question. Yes, Nasreen. See, I told you.
There's a microphone.
Yeah, you're incredible at it. Thank you so much for this conversation. Talking about zoning, I just wanted to kind of bring to your attention that some of these zoning policies were very much relevant just soon after colonial, the post-colonial state, especially in the context of livelihood issues. So let's say, and the abattoirs would be pushed into a particular zone where, cattle killing would be allowed. So in that sense, I was just trying to get a sense of the way that the case law that you described, and when you talked about the ideological underpinnings of it, would you say that the ideological underpinnings, which is deeply embedded in racism or the racist question, sometimes takes over the other aspect of the discussion, especially in the discursive analysis that you were, the way you laid it out in 3 different separate parts? Sometimes the judge's understanding of what in actuality is obviously has nothing to do with the reality, but of the reflection of a much more deep, rooted, racism, which is something that is being carried forward in a very neo-colonial, context of it. Thank you so much.
So, over to you.
Thank you. You make me work very hard. Thank you for that. I have a question to you, Siva, because we're referring to people who are migrating to the Netherlands now, or the people who migrated around independence in 49, 50? Around independence, okay. Then let me start with that question. As I understand it, the people of Indonesian descent moving to the Netherlands around independence were not domestic workers, but were in particular 2 groups. One were Eurasians, so people of mixed descent. And it was a very contested group because they had I imagine, like in India, but I don't know what happened here around independence. Upon independence, the nationality legislation used the colonial classification of the population to assign nationality. So natives became Indonesian, Europeans became Dutch or French or whatever, but let's say Dutch. And the Eurasians, if they were not recognized by the father, they would remain Indonesian. If they had been recognized by the father, they had an option to choose for Dutch nationality. For that category, there was no automatic right to financing of the transfer to the mother country. And if you didn't have financing, you couldn't afford it. This was a completely monopolized transport system. What the Netherlands did was to decide which Eurasians would qualify for funding was to give you one indication to send social workers to relatives already living in the Netherlands and look in how they lived, and in particular look in the kitchen, what they cooked. If they cooked Indonesian food, they would be unassimilable and they would not be funded. If they cooked potatoes, overcooked vegetables and overcooked meats, that's good Dutch fare, then they would be funded. So it's a specific group. The other group, of course, were the soldiers of the native soldiers of the colonial army, whom the Dutch at first wanted to demobilize on Java. And because they had fought for 4 years against the Indonesian army, they were afraid they would be killed. And they had some reason for that. And it took, again, don't get me started, but within 4 months, a case went from the district court in The Hague to the Supreme Court. And all these courts agreed that demobilizing them in Java would expose them to a risk of death. And the Dutch government was forced to transport them and their families to the Netherlands. This was very explosive because this was in a time when legal doctrine held that it was impossible to sue the government. And these people sued the government, and they should have been declared inadmissible. And they not only were declared admissible, they won their case. So it has a very specific background. You asked about the position of these people now. These people are now paraded around as the successful integrated people. They are, and in my family, one woman of Eurasian descent. She regrets that she is not recognized as being Eurasian. So she feels it as a loss of identity because she is taken to be Dutch, and she feels superior to that. So she finds that terrible. And that's even true for the Moluccans, and there was Molukkan terrorism in the 1970s. People were killed, and there were Israeli-style endings of train hijacks and so on. That were very militarized response. Even this group is now considered a lighting example of integration, as opposed to all these Moroccans and Turks. So let's say they're doing well, in a way. Okay, I'll try to speed up my answers a bit. Paula, your observation about the logic of not recognizing this as labor because it gives you more control, sure, that's exactly what it is. And even if you have, that's of course, and the more it's a live-in domestic worker, the bigger the control is. If it's an undocumented domestic worker, live-in or not, the contract can be terminated at any moment, and the employer can even call the police. And the police depends a bit. In Amsterdam, the police thinks it's not cool to show up, and they say, "Oh, it has our permanent attention. We'll make a note," and then they don't do much. But in other municipalities, they actually do. So yes, but even with a permit, the permit is tied to one employer, and if that employer fires you, you're out. So that makes it for a very, very vulnerable position. Yeah, about Lisbon, what it reminds me of is that I said in 1974 the Dutch government annulled the first version, the prototype of this urban zoning policy that explicitly mentions that it was directed not just against Turks and Moroccans, but also against Surinamese who had Dutch nationality at the time, and that was the impossible point, because the Netherlands was negotiating independence with Suriname, and it couldn't have this kind of local policies, and the government wanted to show how exemplary and anti-racist it was. But in 2005, there was the single other successful litigation against this policy, before a semi-judicial body, the Committee on Equal Treatment. The Committee on Equal Treatment said that this policy, which had then been refined and didn't mention race explicitly, but they said it's indirectly racial discrimination. But they had a very good suggestion. They said you shouldn't have racialized housing permit policies. You should have, they said, you can reach the same laudable aim of a more balanced composition of the neighborhood, all code words for less brown people, by gentrification, by building bigger apartments, new apartments, making one apartment, a big apartment out of two smaller ones. So you should make the buildings racialized, and that is no problem. So the Equal Treatment Commission was very helpful and said, we have a good idea for you. That's the direction it goes. And lastly, to Nasri, I think that the judges in the Strasbourg court and in the Dutch courts that dealt with the same case, and with the same kind of cases, they would deny the ideological aspects that I specify. I think that a main process in the text, in these lengthy and very elegant and learned and well-developed texts, it's very high quality case law. And they paid a lot of care to get it right. is precisely not to say that this is about dispersing unruly subjects. It's serving their interests. We're trying to do the good thing. These people live in a hard place, and Ms. Garib, they explicitly say in the judgment, Ms. Garib was not allowed to move 50 meters around the corner, but she did go to another neighborhood 5 years later. And that was better for her, because then she was in a whiter neighborhood. And of course, whiter is better. Yeah? And so, but of course, that's my ironic summary. But so they say, no, she improved. And so it did become better. And that's the purpose of this. And it's a bit tough. We can see it was frustrating for her. So I think the last part of my talk is precisely what they try to push under the carpet, not to say, to stay away from the classical denial. So this is there's a book, a chapter title in a book by Duncan Kennedy. It's called "Denial, Not Just a River in Egypt," and this is a good example of that. Yeah, so I think this is the submerged rationality under the judgment, and judges would deny and would become angry if they would ever be forced to listen to what I have to say about it.
Thank you so much, but you're not allowed to leave this place, because we will continue with a little bit of introduction about the book that you were talking about for the young scholars. If you can tell the scholars here what you are thinking of, so that is a possibility for them. So that's why maybe 15 minutes, just introduce the subject, and then they can have discussions with you when they have the time.
Okay, I didn't see this coming at this particular moment, but of course I can do it. I have to look up my document. And I have it now, so thank you. Okay. Thanks for this. This was very instructive. As you may have noticed, I've been making notes, and I learn a lot from this. I learn enormously from your response and contributions, and from your sometimes you're very critical, and so I learn a lot here. And now for something completely different. And I feel a bit guilty about keeping you from dinner, but here we are. I'm currently engaged at Ghent University in a team of 6 people in a research about the case law of the Inter-American and African Court of Human Rights and UN Human Rights Committees on migration, which we think is fundamentally different from the European Court of Human Rights. So we try to take a global perspective on human rights and migration. Last year, I got an invitation from a publisher, De Gruyter, or De Gruyter, whatever you call it, a big publisher, international publisher based in Germany, who asked if I wanted to edit a handbook, a research handbook on human rights and migration. At first I thought, no, boring. Let somebody else do that. But then I thought, I think, because I was just in the process of hiring 5 people, and thinking of a global project, and the footnote to the word global, which I can hear you formulating in your head, I will make in a minute.